Good morning. Please be seated. The sitting is now open. The court meets this morning to hear the second round of oral observations of Timor-Leste on its request for the dedication of provisional measures. Let me immediately call upon Sir Eliho Lauterpacht. You have the floor, sir, please.
Thank you, Mr. President, members of the court. I'm sorry not to be able to provide the court with a written text of what I'm about to say. However, I have no doubt that the court's excellent interpreters, to whom we are much indebted for their admirable work, will be able to cope with it. They will have no problem in following me. Now, Mr. President and members of the court, it's obviously a cause of regret to me that I should have caused offence to the government of Australia and to my former colleagues. If I may have sounded harsh, there was no intention to hurt, but the word inexplicable was the only word I could think of to describe the what and the why and the when of the seizure of the property in Canberra, property belonging to the government of Timor-Leste. And it is only yesterday morning that there has been an attempt by Australia to justify it in a specific and comprehensible manner. I just refer to a couple of passages in the speech of the learned Solicitor General at paragraphs 51 to 53. Australia is entitled, he said, to have a legitimate concern that a former officer of one of its intelligence agencies may have disclosed and threatens further to disclose national security information, conduct which is likely to constitute a serious criminal offence under Australian legislation. Australia is further entitled to be concerned that Timor-Leste is encouraging the commission of such crimes under Australian law. And he then continued, to place classified information in the hands of a foreign state is a serious wrong to Australia, as it would be with any nation. And lastly, he said, the true object of Timor-Leste's request for provisional measures is to prevent Australia from taking steps properly available under its domestic law to protect itself from a threat to security posed by a disaffected former officer. Now, Timor-Leste would be the first to acknowledge the right of a state to protect itself. But certain questions remain. From what? Protect itself from what? By what means? And when? As to from what, is it protecting itself from the likely revelation that Australia's security seriously and illegally entered Timor-Leste under false pretenses, then surreptitiously placed listening devices in the government offices of Timor-Leste, eavesdropped and extracted information to which they were not entitled, and which we are bound to presume facilitated their own thinking. So Australia does not want the details of the publicly revealed, the details of this publicly revealed, and threatens action against the ex-officer who is blamed for the revelation of this perfidy. Now, by what means? To seize possibly incriminating materials from the premises of a lawyer in Australia, materials belonging to Timor-Leste, and held on its behalf by the lawyer. And when the lawyer was out of his office, out of the country. So why now? Only because Australia had become aware of the prospect that the material involved might somehow be used against it in the arbitration proceedings, or because it wished to cause apprehension in those who might give evidence against it in the arbitration proceedings. And did Australia even consider that the documents might belong to its neighbour Timor-Leste? The court has not heard a word denying Timor-Leste's ownership of the material. Australia has chosen to treat the material as if it were ordinary, and then I use an adjective they employed, commercial material, beneficially owned by the lawyer concerned. It has not said anything to deny Timor-Leste's ownership. Australia denies Timor-Leste's entitlement to the protection of its property. It argues that for Timor-Leste to claim title to material in Australia is a new form of claim to extraterritorial jurisdiction. Nothing of the kind. Property ownership is property ownership, not to be confused with any recognized form of extraterritorial jurisdiction. State property cannot be seized or interfered with. It is the immunity attaching to such property in the hands of an agent that we are concerned about. There was no loss of title, but it was simply in the custody of a person acting on their behalf. No word was said in reply to the authorities supported by the authorities cited by Timor-Leste, like Rahim Tullah's case, the Christina, Yuan Ismail, all decisions of either the House of Lords or the Privy Council or the Court of Appeal, in which recognition was given to the title of the state in the property held by the agent. No word was said about, for example, the precedent of the United Kingdom recently in protesting against the Spanish seizure of papers in Spain. I likened the seizure to the taking by a state of part of its neighbour's territory. And I wish to emphasize that there is no difference between the taking of territory and the taking of property. That's only a matter of a matter of size, not of quality. A taking is a taking. Now, all of Australia's position appears to rest on the invocation by Australia of the possibility of recourse to Australian domestic legal procedures. No answer is made to Timor's submission that the exhaustion of local remedies is not relevant to this matter. We have given the court authorities like the Court of Channel and so on, but no answer is given to their invocation. Now, Australia complains in passing of the failure or lack by Timor-Leste to file written observations prior to this hearing, as Australia did. There must be some misunderstanding. Australia put the failure in terms of a failure to respond to an invitation by the court. There was no such invitation. I cannot find any reference to such a possibility in the court's statute or rules, nor amongst our papers is a copy of any invitation. Timor-Leste is certainly grateful to Australia for its own written observations, but they fail to deny Timor-Leste's ownership, and they repeat the constant reference to local remedies available in Australia. But there is no way in which Timor-Leste can be criticized for not having put into writing our own written observations. One needs only to recall the fact that the application instituting proceedings in the case was made on the 17th of December, and that it was followed on the same day by the application for provisional measures. No invitation came from the court to supplement that request. Nor is it necessary for Timor-Leste to anticipate this week's proceedings. It is sufficient that Timor-Leste's case is stated in front of you, Mr. President, and members of the court yesterday and today. There was a certain reference in the Australian contribution to balancing of interests. Now, in advancing balancing of interests, Australia places all the emphasis on its interests. It seems to disregard Timor-Leste's interests, but they cannot be disregarded. Timor-Leste has a security interest of a very specific kind, namely the protection of the privacy of its internal government discussions. Australia makes indirect threats aimed at witness K and even at Mr. Colliery. In so doing, it failed to take into consideration two items of prospective prosecution. First, if the criminal law enforcement authorities in Australia adopt what I might call an even-handed approach, the possibility of prosecution in Australia of persons concerned with ordering or administering the activities which are themselves a violation of Australian law. That needs to be taken into account. And against it, the possibility that the prosecution can be started in Timor-Leste against those responsible for the initiation of the interceptions in the government offices. Such proceedings under Timor-Leste criminal law obviously would take place in the Timorese courts, but they would be entitled to seek the assistance of the Australian authorities in presenting the accused for trial. The significance of the latest undertaking by the Attorney General needs to be mentioned. Only now does it extend to maritime delimitation matters. I mean no disrespect to the Australian Attorney General when I say that his undertaking should be backed up by an order of the court that deals with the treatment of the materials. I come now, Mr. President, to my concluding point. I'm fortunate in having the benefit of knowledge of what Sir Michael Wood will say, and he will cover quite a number of other points. I know that Latin is not the favoured language of Australia. Even so, it would be better if Australia were to say culpa, mea maxima culpa, and thus admit its blameworthiness now. By so doing, it could put this whole sorry affair behind us. Let Australia restore the materials forthwith, and in the arbitration, incidentally, accept that that the CMATS treaty never properly came into existence. Australia has it in its power to restore a proper basis for the maintenance and improvement of friendly relations between the parties. Mr. President, that is all that I wish to offer the Court. I respectfully ask you to call on Sir Michael Wood. I thank you very much for allowing me to speak, and I need hardly say that it is with the greatest displeasure that I leave you now. Thank you, Mr. President.
Thank you very much, Sir Elliot. And I call upon Sir Michael Wood to continue in presenting observations of Timor-Leste.
Mr. President, members of the Court, I shall respond to what the Australian side said yesterday concerning the conditions for the indication of provisional measures. But I should like to begin by quoting, as Sir Ellie has just done, the Solicitor General, Mr. Gleeson. At paragraph 39 of his speech, he said this: "These disclosures threaten our security interests. The security interests are broader than the fate of the arbitration. To place classified information in the hands of a foreign state is a serious wrong to Australia, as it would be to any nation." Quite. And to seize classified information from Timor-Leste is a serious wrong, as it would be to any nation. Mr. President, I'd like to turn first to Judge Q.Onsado Trindade's question which was put to both parties. The question read, what is the impact of a state's measures of alleged national security upon the conduction of arbitral proceedings between the parties? In particular, what is the effect or impact of seizure of documents or data in the circumstances of the present case upon the settlement of an international dispute by negotiation and arbitration? I shall try to answer that question both as a matter of principle and as it applies to this case. But the short answer is that the seizure of documents makes the settlement of international disputes much more difficult. Trust is lost, relations are poisoned. States should refrain from allowing national interests, including national security interests, important though they may be, adversely to affect international proceedings between sovereign states and the ability of sovereign states to obtain legal advice. Nothing should be done which would infringe the principles of the sovereign equality of states, non-intervention, and the peaceful settlement of disputes provided for in Article 2.3 of the UN Charter. These are at the core of the international legal order as reflected in the Charter and other key documents such as the Friendly Relations Declaration. Applying this to the case in hand, we look to the court to ensure that Australia does not secure unfair advantage either in the context of litigation or more broadly in the context of the Timor Sea. Both parties seem to agree that legal privilege is a general principle of law and is not without limitations. But the parties seem to disagree on the scope of these limitations. In response to Judge Q.Onsadu Trindade's question, I would point to the difference between such limitations under domestic law, as argued for by Australia, and limitations under international law. The domestic limitations argued for by Australia should not apply when a sovereign state seeks legal advice. Australia is not entitled to restrict Timor-Leste's ability freely to communicate with its lawyers. There is no limit on immunity in respect of diplomatic documents on Australian soil. There is no reason of principle why the same should not apply to a state's claim to privilege in respect of legal advice. In any case, any assertion of a limitation on privilege should not hinder Timor-Leste's preparations for international proceedings or negotiations. This principle was expressly recognized in the Libananko case. Contrary to what Mr. Burmester said yesterday, recognition of this principle should not preclude Australia from continuing any criminal investigation. It would just ensure that Timor-Leste's documents remain inviolable, notwithstanding that process. Mr. Campbell began by asking you to keep in mind the alleged general principles applying to provisional measures set out in Australia's written observations. As we made clear yesterday, we do not regard as convincing what they had to say on these matters. The written observations take a very restrictive view of provisional measures. Yet the institution of provisional measures is essential to the judicial process. Its importance is increasingly recognized by international courts and tribunals. Of course, like any judicial process, it can be abused, but courts know how to deal with that. And Mr. President, we reject any insinuation by Australia that Timor-Leste is acting abusively in seeking provisional measures. In particular, we reject the unworthy suggestion by Professor Crawford that Timor-Leste is using these proceedings to skirt around the confidentiality provisions of the arbitral tribunal and maximize the opportunity for publicity and comment prejudicial to Australia. We are not. You only have to look at the terms of our letter of 16 January in response to Australia's request concerning confidentiality to see that that is not the case. Mr. President, the Court has been placed in a rather awkward position by Australia's attitude to prima facie jurisdiction. Yesterday, Mr. Campbell said while Australia may well contest the jurisdiction and admissibility of Timor-Leste's application commencing proceedings at the merits phase, or earlier, we hope not, it will not be raising these matters in relation to Timor-Leste's request for provisional measures. Yet, Mr. President, the Court needs to satisfy itself that it has prima facie jurisdiction. So Australia's attitude is quite unhelpful, if not disrespectful. Professor Crawford, at paragraph 22 of his speech, hinted that the present proceedings might, I say might, because he did not develop the point, be caught by exception A in Australia's optional clause declaration, any dispute in regard to which the parties thereto have agreed or shall agree to have recourse to some other method of peaceful settlement. That is far-fetched. The two cases before the arbitral tribunal and before this court are entirely distinct. We do not believe there is any reason for the court not to conclude that it has at least prima facie jurisdiction. Before leaving Professor Crawford's statement, let me say that I found his attempt to show that our concerns about the documents did not go beyond the arbitration wholly unconvincing. He none too subtly emphasized some words in certain documents and tried to skirt around, to use his expression, others which made clear the scope of our concerns. His assertion that it is difficult to be precise about the documents seized, covering wider matters than negotiations because they're currently under embargo, is also pretty unconvincing. In many cases, it is perfectly clear, as we showed on Monday. LPP 005, for example, is entitled Correspondence to Low QC re Timor Sea Maritime Boundary Issues. We dealt at some length on Monday with the rights under international law that are at issue in this case. Australia has skirted around most of the points we made. Mr. President, Australia likes to exaggerate. As Sir Elihu has just pointed out, Australia accuses Timor-Leste yesterday of creating a new form of extraterritoriality, which amounts, as they said, to a quantum leap in the expansion of public international law. They have said that we claim an absolute right. Mr. Gleeson added that our argument renders superfluous other accepted immunities under international law. Yet Timor-Leste's position does no such thing. It relies on the principles reflected in all immunities that substantive law, which normally applies, cannot be enforced against the state, be it in relation to its diplomats, its special missions, or its property. As the court said in Germany, Italy, immunity may represent a departure from the principle of territorial sovereignty and the jurisdiction which flows from it. The relationship between immunity and substantive law was further addressed in that case, where you said, moreover, as the court has stated, in the context of the personal immunities accorded by international law to foreign ministers, the law of immunity is essentially procedural in nature. It regulates the exercise of jurisdiction in respect of particular conduct and is thus entirely distinct from the substantive law which determines whether that conduct is lawful or unlawful. And later, you said, the two sets of rules address different matters. The rules of state immunity are procedural in character and are confined to determining whether or not the courts of one state may exercise jurisdiction in respect of another. They do not bear upon the question whether or not the conduct in respect to which the proceedings are brought was lawful or unlawful. So the fact that Australia claims that its seizure of property in the possession of Timor-Leste's attorney has been carried out by a warrant issued by the Attorney General as provided for under domestic law is of no relevance. As noted by the International Law Commission in its commentary on the draft articles that became the 2004 Convention, There is a clear and unmistakable presupposition of the existence of jurisdiction of that other state over the matter under consideration. It would be totally unnecessary to invoke the rule of state immunity in the absence of jurisdiction. Timor-Leste's argument is based on this very principle. Be it within the framework of the UN Convention or as a matter of customary law, the immunity of a state's property is relevant precisely because it would otherwise be subject to the territorial jurisdiction. Mr. President, members of the Court, by issuing a warrant for the seizure of documents belonging to Timor-Leste and by seizing and retaining such documents, the Australian authorities breached the inviolability of Timor-Leste's state papers and violated the immunity to which Timor-Leste is entitled under international law. As the Court said also in Germany, Italy, the rule of state immunity occupies an important place in international law and international relations. It derives from the principle of the sovereign equality of states, which, as Article 2, Paragraph 1 of the Charter of the United Nations makes clear, is one of the fundamental principles of the international legal order. Mr. Campbell questioned the current status of the UN Convention, but unsurprisingly, this Court, like a number of regional and domestic courts, has found customary law to be reflected in the Convention, for example, when determining the customary exceptions to the general rule of immunity. Mr. Campbell challenged the view that in issuing the warrant, the Attorney General was acting as a court within the meaning of the Convention and customary law. He said that the Attorney General cannot fall under this description since he is from the executive branch, not the judiciary, and since there are no judicial proceedings when the Attorney General issues a warrant under the ASIO Act. Mr. Campbell simply did not address the points we made on Monday. He did not refer to the definition of a court in Article 2.1a. He did not mention the International Law Commission's commentary on that definition and its interpretation. He did not address the term judicial proceedings or, in particular, the quasi-judicial nature of the Attorney General's role when issuing the warrant in this case. He did not address the term jurisdictional immunities. This is a judge that normally issues a search warrant, but here it has been issued by the Attorney General. This fact is of no relevance for the purposes of the Convention, which is to be interpreted autonomously and not by reference to domestic characterizations. Its object and purpose are served when immunities are granted from seizure of state property, regardless of the formal position of the issuing authority under domestic law. Mr. Campbell appears to suggest that the Attorney General's actions were outside the scope of the law on state immunity. But they are precisely the kind of actions that the law on state immunity aims to prevent. That is why the commentary states that the Convention applies to the exercise of judicial powers by whatever authority. Mr. Campbell's assertion that there are no judicial proceedings involved is also hard to accept. We have heard Mr. Gleeson list a whole series of criminal legislation concerning offences that may have been breached. We know that the ASIO Act stipulates that its violation amounts to a criminal offence. We heard that Australian law does not grant legal professional privilege to documents seized because they came into existence in pursuance of a crime or fraud. In any event, given all these references to criminality and criminal procedures, it's hard to accept that the seizure of the documents and their retention by ASIO is completely unrelated to any future judicial proceeding. And I would recall that state immunity is to apply from the very outset of an investigation by another state's authorities. Mr. Campbell argued that Timor-Leste does not accept any exceptions to the rule of immunity of state property, and that therefore the immunity it argues for is implausible. Mr. President, it's not for Australia or Timor-Leste to accept or make up exceptions. That is a matter of law. The exceptions reflect the fact that state immunity is a customary rule as recognized by this court, and under customary law there are certain exceptions. For example, commercial transactions and in relation to immovable property. But insofar as documents and data in the hands of legal counsel are concerned, there is no such exception. This approach is taken by states in their own domestic legislation. The basic rule is immunity unless otherwise stipulated. One need look no further than the Australian Foreign States Immunities Act of 1985. Article 9 of that Act is entitled General Immunity from Jurisdiction and makes clear that a state and its property are immune from jurisdiction except as provided by or under this Act. Nowhere in the Australian Act does it say that state property in the hands of legal counsel is an exception to the rule of immunity. Mr. Campbell asserts that Timor-Leste claims without basis that state property and papers enjoy absolute inviolability. Counsel for Australia seemed to like the word absolute to refer to what we said. I don't in fact recall using that word once on Monday. Australia is once again engaging in the well-known tactic of overstating a proposition in order to knock it down. Australia was highly selective in the points it chose to address in response to what we said about inviolability and immunity. It ignored the network of treaties and customary law that has developed in respect of those matters, which create a web of interrelated and closely linked rights and obligations, all stemming from the principle of the equality of states, sovereignty and non-intervention. The similarities, both in content and rationale, between the different types of immunity have helped develop and form broader principles of general customary international law. As Sir Elihu has pointed out, Mr. Campbell said nothing about the recent United Kingdom practice. He also said nothing about Professor Denza's references to the inviolability of archives of a foreign state government. He questioned the significance of Mr. Taft's statement. While Mr. Taft accepted that the issues that he was there addressing were novel and complex, one cannot read that as a suggestion that the rights to which he referred were not plausible. That the learned editors of Oppenheim regard official papers in the hands of non-diplomatic agents as presumably entitled to immunity was said to be equivocal. The reverse is the case. Presumably is defined in the shorter Oxford English Dictionary as so as to take things for granted, or qualifying a statement as may reasonably be assumed. As I said on Monday, we read this practice and these authoritative writings as recognizing a general customary rule of inviolability and immunity of state property. They certainly go to show, I would submit, that the rights we assert are plausible. Mr. President, this is a convenient point to address the question posed by Judge Yusuf. He asked, in the view of the parties, to whom did the individual items listed in the ASIO property seizure warrant record of 3 December 2013 and their contents belong? As we explained on Monday, documents in the hands of lawyers on behalf of their clients belong to the clients, in this case Timor-Leste. That applies to most of the items seized. Of course, there were one or two other items, like the mobile phone, which presumably belonged to Miss Preston and which was eventually returned to her. Mr. Burmaster tried to show yesterday that we had failed to demonstrate the necessary link between the rights that form the subject of the proceedings and the provisional measure sought. He said that the relief sought is all about ownership of certain documents and their return. In contrast, the emphasis in the provisional measures A to D is on the use of contents of certain documents and data. That is to misread and misunderstand the application of the request. The application asks the court to adjudge and declare that the seizure and continuing detention violate the sovereignty of Timor-Leste and its property and other rights under international law. That Australia must immediately return all the documents and data and destroy and ensure the destruction of every copy that has been made and afford satisfaction and apology. The main purpose of seeking the return of the documents, and in particular seeking the destruction of copies, is to ensure that the content of the documents does not come into the hands of those who could use it to the disadvantage of Timor-Leste in its relations with Australia over the Timor Sea. Given that the property in question comprises highly sensitive documents, it is as plain can be that the provisional measures sought are related to the rights that form the subject of the proceedings. Indeed, Mr. Burmester seemed to recognize that when he referred to the right to prevent any potential advantage to Australia, any potential advantage Australia may gain from access to the documents in relation to the arbitration and in relation to the Timor Sea resources. It is no answer to say, as he does, that such a link cannot be shown in light of the explicit undertaking that the material removed will not be made accessible to those concerned with the arbitration or to anyone other than intelligence and criminal law enforcement personnel. We did indeed receive a new undertaking yesterday, following what we said on Monday. The undertaking does not, however, go to the link between the rights at issue in the case and the preliminary measures sought. Its relevance, if any, would be to the requirement of irreparable harm and urgency. Mr. Burmester laid great emphasis on measure E, perhaps recognizing that his arguments on A to D were very weak, but we think that the link there is equally clear. Australia clearly considers that it is at liberty to disregard our rights, and we request the protection of the court in relation to ongoing communications with its lawyers. Sir Elihu has said all that needs to be said about Australia's one-sided view of the balance of interests. I think I'll move to my conclusion.
Well, I think Timor-Leste could continue until 7 minutes past.
Okay.
11 as we started a little bit later. Yep.
I'm very grateful, Mr. President. I'll go back a bit in that case. Mr. Burmester argued that there was no risk of irreparable prejudice because the circumstances of concern will simply not occur. And why is this? Apparently because of the undertakings. We've received a new undertaking, and we will look at it with interest in the light of the responses given to the questions. But we were told yesterday that unilateral undertakings by states can give rise to legal consequences, and that the most recent undertaking given by Australia to this court is of that nature. It would be good to hear the agent for Australia say, unambiguously, that Australia accepts that the undertaking given on 21 January is binding on Australia vis-à-vis Timor-Leste under international law. Mr. Burmester suggests that our concerns about wider matters other than the arbitration are mere speculation, since there are currently no boundary negotiations. Alas, that is true. That regrettable fact, however, does not mean that the documents relating to our broader legal strategy are not highly sensitive and should not get into the hands of anyone on the Australian side concerned with such matters. I trust that Australia's statement does not mean that it intends to disregard its obligation to negotiate a maritime boundary agreement in good faith under Articles 74 and 83 of UNCLOS. We're accused of demonstrating a lack of urgency by failing to bring a claim under Australian law. If this were right, it would simply be a backdoor way of forcing foreign states to submit to domestic courts. Anyway, we do not accept that any of the remedies would be effective. We note, for example, that Australia's Administrative Decisions Judicial Review Act expressly excludes decisions under the ASIO Act. We also, despite Professor Crawford's eloquence yesterday, cannot see that any remedy from the arbitral tribunal would be able to cover our wider concerns. Mr. President, in conclusion, let me recall the diplomatic and consular staff in Tehran case. The court there referred to the extreme importance of the principles of law which it was called upon to apply, and it referred to the edifice of law carefully constructed by mankind over a period of centuries, the maintenance of which is vital for the security and well-being of the complex international community of the present day, to which it is more essential than ever that the rules developed to ensure the ordered progress of relations between its members should be constantly and scrupulously respected. The inviolability of state property, in this case, confidential and legally privileged papers, which we seek to uphold with the application and this request for provisional measures, is an essential part of this vital edifice of law. Mr. President, members of the court, that concludes my statement, and I would request that you invite the agent of Timor-Leste to the podium.
Thank you very much, Sir Michael. And I give the floor to the agent, His Excellency Ambassador Joaquim da Fonseca. You have the floor, sir.
Thank you, Mr. President, members of the court. I shall now conclude Timor-Leste's oral argument on its request for provisional measures by thanking the court and reading out our final submission. But before doing that, allow me now to address some remaining points made by Australia in the course of the oral observation yesterday. In his remark, Mr. Gleeson criticized Timor-Leste for omitting to mention the profitable revenue sharing arrangement for Greater Sunrise Fields under CIMAT's treaty. This is not the place to debate CIMATs, but we cannot let that remark pass without pointing out the following. Both the Timor Sea Treaty and CIMAT's treaty are meant as temporary arrangement for the exploration and exploitation of maritime resources in the Timor Sea. But under no conceivable maritime delimitation would the Greater Sunrise Field lie within Australia's territory. They are located within 200 nautical miles from the coastlines of Timor-Leste, far closer to Timor-Leste than they are to Australia. So in the absence of a permanent maritime boundary, the question remains, to whom actually the resources currently shared at 50-50% between Timor-Leste and Australia really belongs? And who is being generous to whom? Mr. Gleeson further suggests that Timor-Leste may be encouraging the commission of crime that threatens Australia's national security. Mr. President, my government is committed to pursue justice in this court. It is equally committed to pursue mutual interest between Timor-Leste and Australia through broader bilateral cooperation. Such expression of distrust falls short of a recognition and appreciation of our broader relationship. I must firmly reject this careless and outrageous suggestion. Our Council have responded to what Australia had to say yesterday morning. I only wish to emphasize again the great importance that my country attaches to these proceedings. Our concern is primarily practical, but also one of principle. Untold harm could be done to Timor-Leste's vital interest in the resources of Timor Sea without provisional measures to ensure that illegally seized materials are not made available to any person having any role in connection with Australia's diplomatic, commercial relations with Timor-Leste over the Timor Sea and its resources. In addition, we ask the Court to uphold the principle that one state may not seize and retain the documents of another state, and to recognize the principle of legal professional privileges in international law. As both councils of Timor-Leste have alluded to, Mr. President, we have of course taken careful note of the new undertakings dated 21st of January 2014. But in addition to the remarks have already been made by the Council, I must say that we await with interest Australia's answer to the questions put by members of the Court yesterday. It remains only for me now to thank you, Mr. President, and all members of the Court for your courtesy and attention, and to thank the Registrar and his staff and the interpreters for all their assistance. I also wish to thank our colleagues in the Australian legal team, especially my friend Mr. John Reid, for their spirit with which they have approached these proceedings. I shall now read out the submission on behalf of the Democratic Republic of Timor-Leste. They remain unchanged from those in the request. Timor-Leste respectfully requests that the Court indicate the following provisional measures. A. That all the documents and data seized by Australia from the 5th Brookman Street, Narrabundah, in the Australian Capital Territory on the 3rd December 2013 be immediately sealed and delivered into the custody of the International Court of Justice. B. That Australia immediately deliver to Timor-Leste and the International Court of Justice, first, a list of all and any document and data that it has disclosed or transmitted, or the information contained in which it has disclosed or transmitted to any person, whether or not such person is employed by or hold office in any organ of Australia's state or any third state. And second, a list of the identities and description of and current position held by such person. C. That Australia delivers within 5 days to Timor-Leste and the International Court of Justice a list of all, any and all copies that it has made of any of the seized documents and data. D. That Australia first destroy beyond recovery any and all copies of the documents and data seized by Australia on 3rd December 2013 and use every effort to secure the destruction beyond recovery of all copies that it has transmitted to any third party. And second, inform Timor-Leste and the International Court of Justice of all steps taken in pursuance of that order for destruction, whether or not successful. E. That Australia gives an assurance that it will not intercept or cause or request the interception of communications between Timor-Leste and its legal advisors, whether within or outside Australia or Timor-Leste. In accordance with Article 60, Paragraph 2 of the Rules of Court, a signed copy of the text I have just read, will be communicated to the Court and transmitted to the other party. Mr. President, members of the court, that concludes the oral reading of the Democratic Republic of Timor-Leste. Thank you.
Thank you very much, Excellency. The court takes note of the submissions you have just read on behalf of the government of Timor-Leste. I'll now give the floor to Vice President Sepulveda, who has several questions. Mr. Vice President, you have the floor.
Thank you, Mr. President. Thank you very much. I have 3 questions to be submitted to Australia. The first one is the following. Does Australia have evidence supporting the proposition that Timor-Leste is encouraging the commission of crimes under Australian law or otherwise jeopardizing Australia's national security, as suggested by Mr. Gleeson in his intervention of the 21st of January 2014 before the court? If so, could Australia be more specific on this particular matter? My second question is the following. In accordance with the Australian Security Intelligence Organisation Act of 1917, Section 25(4)(c), a text which is included in Annex 13 of Australia's Judges folder provided to us in yesterday's hearing, and which says, and I quote, "A record or other thing retained as mentioned in paragraph 4D or 4AC may be retained, A, if returning the record or thing would be prejudicial to security, only until returning the record or thing would no longer be prejudicial to security, and B, otherwise, for only such time as is reasonable." End of the quotation. My question is, should the documents, data and other property seized by the Australian authorities at the premises of Mr. Bernard Collery be still retained by the Australian authorities on grounds that returning them is currently prejudicial to Australia's national security? And my third question is the following. Does Australia consider that, under customary international law, state documents are entitled to international protection in the form of immunity or inviolability outside the framework of diplomatic and consular relations? If so, what is the extent of international protection that Australia claims for its own state documents in foreign territory? Those are my 3 questions, Mr. President. I thank you very much indeed.
Thank you very much, Mr. Vice President. Australia is invited to reply in the course of the second round of oral argument. The text of the questions will be transmitted to both parties as soon as possible. If Timor-Leste wishes to comment on replies provided by Australia, can do that in writing at the latest by Friday, 24 January, 6 p.m. The court will meet again this afternoon at 5 p.m. to hear the second round oral argument of Australia. Thank you. The court is adjourned.